Ms. Howard, how are you doing this
Good
morning?
morning, Judge. Gary Howard, doing fine, thank you.
Mr. Finley, how are you doing this morning?
Good morning, Your Honor. Happy New Year, sir.
Good. You all ready for me to go on the record?
Sure.
Okay, let me go on the record. This is on top of my page 2, State versus Jamell Demons, 23-10594 CF10A. I've got Ms. Bucklew, Mr. Griffiths here in person. I've got Ms. Collins on the Zoom call for the state. I've got Ms. Howard, Mr. Finley present in person, with Mr. Demons, who also likewise is present. I put this on for today and for tomorrow for all pending motions. Let me put a couple things on the record, and then I won't limit either side in any way regarding any evidence, witnesses, or testimony they want to present, or if it's just their argument as to each. And then I'll give you rulings as to each. In preparation for the hearing today and tomorrow, I did review the following. Number one, the defendant's motion to inspect and photograph Jamell Demons' cell in conditions of confinement. That's electronically filed December the 29th, 2025. Defendant's motion to bifurcate gang enhancement contained in count 1, count 3, and count 4, electronically filed December 29th, 2025. The defendant's amended motion in limine to prohibit the introduction of out-of-court statements and irrelevant evidence, electronically filed December the 29th, 2025. The defendant's motion for statement of particulars as to count 2, electronically filed December the 29th, 2025. The defendant's motion to sever count 2 from counts 1, 3, and 4, and 5, electronically filed December the 29th, 2025. The defense motion for additional time to file a motion to suppress, electronically filed December the 29th, 2025. And the state's response to the defendant's motion for statement of particulars as to count 2, that was electronically filed January 2nd, 2026. So I did review all the motions. I did review all the authority cited therein. So I guess we'll just take them one at a time. Defense, when you're ready, you may proceed. You can stand at the podium.
Okay. So what I'm going to do, Your Honor, what I'm going to do real quickly is kind of give Your Honor the chronology of communication amongst the parties. So I'll start off by saying I feel confident that the state will agree tomorrow won't be necessary. So we filed the motions on December 29th, giving the state attorney's office the opportunity to review those. We began communication with them on December 31st. They assured us they would look at everything, and they kept their word with great precision. And on the 2nd, we opened the line of communication so that we could have today go more efficiently. And so I'll give the court, with Your Honor's permission, a rundown of where we are, and then invite the state to correct any of my errors if I make any.
Yes, sir.
So with regard to the motion to inspect and photograph Mr. Demons' cell, the state attorney's office takes a position that they don't take a position, that that's up to the sheriff's department. And so we reached out to the legal department, and so what we'll try to do, Your Honor, is resolve that without the involvement of the court, see if we can reach a resolution on that. If it's necessary, we'll let the court know. But we're going to try to reach that resolution outside of the court's involvement.
If you do need me to hear that, and this is reset, I'll just say we'll defer onto this one and make sure that they're noticed for the hearing in court. They got to be in the notice of hearing. Did you talk to Mr. Sabanos?
We sent an email and believe that no one was available yet to review it. But the jail has been responding to all of our requests very, very quickly.
Okay.
Since we've gotten involved in the case, so we have no doubt that they'll respond pretty quickly. Regarding the motion to eliminate, there have been some positions by the state. I'll let Ms. Howard come and address that, because that involves a number of subject matters, and I think there'll be an agreement between the state and the defense on what they'll not be going forward with. So I'll skip over that. The motion to sever count 2 from counts 1, 3, and 4. My understanding is that the state will
close that.
completely agreeing to their motion. I'm severing the count on our own, and so the motion is moved at this point.
So we'll bifurcate the proceedings. We're gonna go forward on the other 3 counts. By the way, separate and apart from our discussion today, my office should have emailed everyone this morning some proposed preliminary, let's call them preliminary jury instructions. Again, I'm not married to any of that. If and when, and only if, we get to the end of all the evidence, I'll give you a charge conference, just like normal, and I'll be happy to listen to either side with any requests of things they wanted added or deleted or changed. But in the preliminary instructions, I did in fact do it where the first 3 counts would go first, and then the count 2, the gang activities, would be bifurcated. So, Ms. Bucklew, you're moving to do that yourself?
Yes, Your Honor.
Okay, so then based on that, without objection from the state, that one's going to be granted. The trial will go forward as to counts 1, 3, and 5 only. For purposes of what the jury sees, I'm going to call those counts 1, 2, and 3, but on our information, it's count 1, tampering with a witness in a capital felony, count 3, solicitation to commit tampering, and count 5, conspiracy to commit tampering.
And Judge, I typed up an order.
Oh, okay, let's see what you got.
I showed defense counsel.
Okay, Mr. Finley, no objection to this?
No objection.
Okay, so this one's going to be granted and entered. Give me 1 second. All right, yes, sir, what's next?
Regarding the motion to bifurcate gang enhancement as to counts 1, 3, and 4, the state has agreed to forego enhancement on those counts, and I think they prepared an order, like a UV order, and have no objection to the order as it's drafted.
That's correct, Your Honor. We're going on the gang enhancement on those other counts.
All right, so you're not gonna seek it at any point?
No, and the only caveat is if somehow the door is open, gang evidence could come up, but otherwise we're not going forward on the enhancement of the trial.
Okay, so hypothetically, if the defendant got convicted on one of those counts, you're not going to want to present any additional evidence, and you're not going to be asking for that enhancement to be
No,
included?
Your
Okay, so no objection to this order, Ms. Buckley? Okay. So then, otherwise, that one by the agreement of the parties is granted. Give me 1 second. Yes, sir.
Your Honor, the remaining motions, the statement of particulars and the motions for additional time to file motions for us, I'll let my field counsel Ms. Smith address those.
Okay.
And Judge, I actually just thought something on the motion to bifurcate issue, because this is Massachusetts is technically still running on count 2 then. So how would we go about that?
Well, I mean, my position would be once we start jury selection in the case, it's started. It's bifurcated only for purposes of how we're going to handle it, but it's going to be the same jury, it's going to be the same trial.
Okay.
I think once jury selection starts, Speedy's been satisfied, but that's just my take. All right, so that handles those. So Ms. Howe, whenever you're ready.
I
Anything else you want to tell me? I got the motion for statement of particulars, the motion for additional time to file any motion to suppress you might like to, and your amended motion in limine, which involves several separate paragraphs.
Yes, thank you, Judge. And may I request that Mr. Demons have at least one hand on the clock for purposes?
Yeah, that's fine, Gary. That's fine. That's fine. Okay, let me just press pause real quick. All right, real quick 5-minute break, okay? We'll be in recess for 5 minutes. Okay, listen, he's got to have a hand. He's done nothing. He's behaved perfectly like a gentleman. This is Jamell Demons, 2310594 CF10A. I continue to have Ms. Buckley, Mr. Griffiths present in person, Ms. Collins present on the Zoom call, Ms. Howard, Mr. Findling present in person, with Mr. Demons who continues to be present. Yes, ma'am.
So, Judge, I would ask that the next motion we hear is the amended motion in limine.
Sure.
We do have some agreements as to this.
Okay, you want to just go one paragraph at a time?
So paragraph 1, I believe there's an agreement.
Yes, Judge, and same caveat, as long as the door is not open for whatever reason, we do not intend to enter that evidence.
Okay, so as to, this is the defense amended motion, paragraph number 1, the YouTube videos by 1090 Jake, you don't state you don't want to use any of those unless the defense makes it relevant. So.
Correct.
Okay, so that one is granted then with that understanding. As to paragraph 2, yes, ma'am.
Judge, may I just ask that should the issue come up as to whether or not it would be used that the approach sidebar, if there's some belief that it's the door fit into it or something of that nature?
Yeah, that's fine. And if you need me to send the jury out to have that discussion, I'm happy to do that too. It's not a
Okay.
problem. Okay.
And the same with paragraph 2.
All right, state your same position as the TikTok video of Neek Baby, NEAKBABY. Is that correct?
Correct, Your Honor. I informed the defense that we would not be playing the video. I might use a screenshot because of the username, which was part of the investigation as to identifying users on the book.
Okay.
But we would not be playing the video.
Okay, so same ruling as to paragraph number 1. As to paragraph number 3, statements by James Howard. Yes, ma'am.
So, Your Honor, provided in discovery are literally hundreds of phone calls of James Howard to a whole bunch of different people. And, but none of the calls appear to have anything to do with Demons. There appears to be a call where he indicates to someone, he knows Melly, quote unquote, or he needs to talk to Melly, quote unquote. But there is nothing that indicates there's any conversation from James Howard to somebody about that would be relevant to the charge of tampering evidence.
State you want to use these statements?
We do plan on using the statement, not the irrelevant call, Your Honor, but in the warrant affidavit, PC affidavit, it does spell out that there are numerous calls between James Howard and one of the defendant's girlfriends, Erin Burnett. There were, I believe, 26 calls made to Courtland Henry, calls to Erin Burnett. There's some calls that discuss ASAP Rocky with Mr. Henry, which is part of the tampering case that we plan on presenting. So there are calls that are specifically laid out within the warrant affidavit and the PC affidavit that state which calls we would likely use.
Okay.
All the other calls are irrelevant.
Okay, so for this one, I'll defer on it. Again, each side can make whatever appropriate objection they need to at the time of trial, again, I'll repeat, if it's an issue that I need to send the jury out to have a more thorough discussion with the lawyers, I'm happy to do that. If the parties aren't in agreement on some of these, I don't know any other way to do it. I don't know what the evidence, witnesses or testimony are going to be at the trial. I would need to hear what that is to determine if this evidence is admissible, if it's hearsay, if there's a hearsay exception, if it's relevant. So as to paragraph number 3, I'm going to defer. That statement's by James Howard. Paragraph number 4 is phone calls between Cortland Henry and Juvy Molina, which is Juneviah Molina, Molina. Yes, ma'am.
I believe the state is in agreement with this.
Yes, sir, and I informed this morning that we don't plan on using those calls unless there's a reason I find a call that explicitly has something that shows the conspiracy is still ongoing. I would let them know ahead of time, but as of right now, no.
Okay, so that one is, again, granted, based on that caveat. Number 5, hearsay statements contained in writings and phone calls of Terrence Mathis. Yes, ma'am.
And Your Honor, I put this in a motion when simply to really alert the court. I think that this is going to be an issue I'm sure you're going to want to defer on with regards to the sufficiency of the evidence of a conspiracy. Mr. Mathis is not testifying as a witness. To the extent to which his statements or writings are admissible, I assume the state would be relying on co-conspirator hearsay. And of course, the law is very clear that conspiracy has to be proven prior to the admission of co-conspirator hearsay. So I recognize this is a difficult issue for the court to rule on ahead of time without hearing what evidence may be presented. But I think it's important that it is raised at this point so that we're not jumping into hearsay, having objections in front of the jury, all of that. So I really am wanting to put the court on notice that this is a concern of ours and one which I think the court is going to have to address.
Okay, and you want to use this?
We do, Judge, and I think you will disagree on this, but the state's position is that the writings that we intend to use, the calls that we intend to use, while it is maybe Terrence Mathis's voice on the call, it is actually the defendant's words. They're his letters. We do have jail video we intend to present where he is, and it's all explicitly stated in the warrant affidavit and PC affidavit, where the defendant is holding what appears to be a kite, which is a letter. It passes jail. It goes under his door. Another inmate takes it, passes it through the wall. Another inmate grabs it on the other side of the wall and presents it to Mr. Mathis, who then walks over to the phones and makes a call to Cortland Henry. And so that
Okay.
video is there. I can provide Your Honor with the calls that we intend to use to make rulings ahead of time, but I do think there are multiple layers to these calls. The first layer, not even being co-conspirator statements, I would say they're not being authentically not asserted, but it's a statement of legal significance, aka an operative fact, therefore not hearsay. And then the other statements that would not fall under that hearsay, non-hearsay ruling would be the co-conspirator statements. And I do believe there is sufficient evidence, either just spelled out in the affidavit or PC affidavit, to explain that there was a conspiracy going on. Obviously, under the evidence standard, we do have obviously the verbal acts that we would not consider hearsay as part of the conspiracy. We have the James Howard calls to Mr. Henry. We have payments made by Mr. Demons to Mr. Mathis's attorney, George Perez. We have the defendant's phone privileges revoked. We have texts between Mariah Hamilton and Juniva Molina. We have other calls Mr. Mathis made to Cortland Henry about Ms. Barnett. We have Ms. Hamilton not showing up for trial or deposition. And we have that jail video. Just to name a few.
Yeah, last word on this one. Go ahead.
Thank you. About 80% of what was mentioned appears also to be hearsay. I'm not sure what statements of legal significance mean in terms of the exception to hearsay rules or operative facts. But it does seem like it is going to be issues we're going to have to address as we see how the evidence comes in. I would remind the court that the dates alleged are April 10th through July 22nd, 2023. And the state has been very cooperative with providing discovery, so I'm sure we're going to get this information. The videos we have at this point appear to all have occurred after the dates which charged in information, but that might just be how they came across. So we'll have a chance to hopefully work that out and see if they're really intended to use. I know from the court order that we have to have exhibits.
Well, just so you all see them.
Yes.
You don't have to turn
yes.
them into me. I
I
just.
know, but that will give us a chance to.
Yeah. Okay. All right. So I'm paragraph number 5. Hearsay statements contained in the writings and phone calls of Terrence Mathis. I'll defer on that one, and I'll give you a ruling at whatever time it arises during the trial, based on whatever objection either side thinks they need to make. So.
Judge, if I may, I'm sorry, obviously, the majority of paragraph 5 and what we'll be arguing about is a lot of the same statements. So we would really need a ruling prior to the jury being sworn, because obviously that would affect whether or not we go forward. So if I may, maybe we can put together some of the calls for your honor to listen to, and we can have another hearing date where it's argued prior to the jury being sworn.
I mean, if you want to turn something over to me and have me reviewed ahead of time, as long as they have it, and they don't object to it, I'm happy to do that. I've never heard any of these calls. I've never seen any of these writings, so this is all in a vacuum to me.
And just so, you know, the argument really is the conspiracy has to be proved, not through the hearsay. So, having the phone calls aren't going to necessarily give the court the information needed to determine whether there's independent evidence of the conspiracy so as to allow the phone calls that are hearsay. So I think that almost requires an evidentiary hearing.
The state's arguing that some of these calls, some of the statements within the calls are not hearsay.
Yeah, listen, I'm not quite sure how I can do that before the trial, but I mean, I'll try to craft some time for you, and this isn't something you want to do tomorrow.
I would have to get all the calls together and like take some time on the calls, but I can try. I don't know.
Okay.
Try.
Well, as to that one, I'm going to defer on it when we get done with our discussion today. If you want me to schedule something in the future, understanding that I'm sure you all know, I'm starting another capital case on Wednesday, so I might have a limited amount of time, but I'll do the best I can for you. On my case on Wednesday?
I might be able to.
Well, I think I'm going to decline that invitation at this point.
No,
but-
it's scheduling purposes why, it's not anything with the actual case.
Okay, well, press pause on that. Number 6, the resolution of Cortland Henry's case and the resolution of Terrence Mathis's case. Yes, ma'am. All right, you're not going to introduce any of this.
Correct,
All
unless
right.
again, caveat of the
All right, so that one's granted. We're not talking about how they resolve their cases. 7, any mention of the counts of the information that only charge Terrence Mathis and Cortland Henry. Yes, ma'am. You guys aren't? Okay. So, Ms. Buckle, if we get that far, and you've tried plenty of these cases with me before, we would need a dummy information for the jury, which would only contain, since we're bifurcating, the 3 counts that would be for their consideration. And you can remove the numbering, just the language, and just show it to defense. And just so they're aware, I give each juror a copy of the jury instructions, and I would give the jury as a whole this single dummy information, which just contains the actual language that's in the paragraph of the information, nothing else. So there would be nothing going back to the jury regarding the counts that do not include Mr. Demons. Number 8, the fact that Mr. Demons is charged with a capital felony. Yes, ma'am.
And it would be our position, Judge, that the fact of the capital felony is also a sentencing enhancement, and that it is prejudicial to Mr. Demons for the jury to know he's under indictment for murder, when it is not necessary to the charge itself. The allegation is not an element of the offense, it is a sentencing enhancement. Punishable by life, and I think the court can take judicial notice of this, or obviously we can stipulate to this, should there be a conviction on this.
State your position on that is?
Well, Your Honor, at first I was a little confused with the wording of it, and I did bring that up to counsel, because the title says the fact that Mr. Demons is charged with a capital felony, so I was in agreement, obviously, not to talk about sentencing, or that it's a capital felony, that Mr. Demons life or death. charged with murder is the underlying offense as to the tampering, and that is completely relevant to this case, to the serious nature of the case as to why a witness might be tampered with. You can't try our case in a vacuum at this point, and it's very typical for the underlying charge to come in and for the court to take judicial notice of it and just to discuss basic facts of the case in order to establish the tampering without making it a feature of the case.
Well, I'm looking at 21.10, the standard jury instruction for tampering with a witness pursuant to 912.22, subsection 1, which is exactly what Mr. Demons is charged with. To prove the crime of tampering with a witness, the state must prove the following 3 elements beyond a reasonable doubt. And the third element is the official investigation or official proceeding or offense or violation of a condition of probation, parole, release, affected, attempted to be affected, involved in investigation or prosecution of a, and then they give me a list of choices, and one of those is the capital felony. It's an element of the crime. So, over the defense objection, I think that one's going to be denied. It's an element of the crime. So, the defense's objection is duly noted, but I certainly can't prevent the state from introducing evidence of something that they're required to introduce to prove their case.
So, I'm sorry, Judge, if I just ask for clarification.
Sure.
That would allow the state to introduce evidence that Mr. Demons is charged with those offenses.
Yeah, that's all they have to prove.
Yeah.
That he's charged with. Yeah, I would certainly limit the evidence as to that. The focus of this trial, the focus of the underlying offense, whether he may be, and I think I read in one of your pleadings, he may be actually innocent of that offense. He's presumed innocent of that offense. That still doesn't change the fact he can be charged with tampering with a witness. But it's an element of the crime that he is charged with a capital felony. And then the standard instruction goes on to say the court instructs you that first-degree murder is a capital felony. So I'm going to allow the state to do that. I would certainly limit it. It's not going to become a feature of this trial. What the underlying circumstances of that alleged crime are. But the fact that he's charged with the crime, I think they're certainly allowed to introduce that from the jury. All right, number 9, music lyrics published by Jamell Demons. Yes, ma'am.
So, Judge, it's our position that there's lyrics that have been provided in discovery, and none of the lyrics were written during the time alleged in the information with regards to witness tampering. The lyrics don't have any relevance to witness tampering, and so it's our position any lyrics are irrelevant to the determination of Mr. Demons' innocence or guilt, and immaterial. As the court knows, Mr. Demons has been in custody since 2019. So any and this information is charges April to July 2023. So I can't conceive of how lyrics would be admissible.
Do you all want to use any of those?
I told counsel this morning I did not plan on using any of the published lyrics. I did use the caveat of within the phone, defendant's phone, there might be notes where there's some lyrics where he mentions Mariah or what he calls Riri, but those aren't official lyrics. We don't intend to use any of the official lyrics. We provided them separate.
All right. I mean, so that one's granted, again, based on that caveat. Number 10, social media posts, Snapchat records, phone records, and Instagram messages from 2018 and 2019. Yes, ma'am.
Yes, as the court knows, the prior judge suppressed a great deal of this, but some of it for the murder case he ruled was admissible. There were new warrants issued, but all of those accounts are from 2018 to 2019. So it is our position they would not be relevant. They are remote in time from this incident, and there would be no evidentiary value in this evidence in the charges, the present charges that, as I say, are alleged to have occurred in 2023.
Yes, ma'am.
So Judge, I would object as to this paragraph as being too broad. There are things within these records we don't intend to use for purposes of this trial, again, not making the homicide a feature of this case. However, we do have to prove that there was a relationship of some sort between Ms. Hamilton and the defendant and other witnesses in this case as to how she was tampered with. Including in those records are phone numbers to prove numbers being called from the jail, social media pictures to show that they had a relationship, things of that nature, or nicknames used, things like that, because the calls use nicknames, they use code. So it would be introduced minimally to show those particular types of items, but not extensively to obviously try the homicide again.
And the whatever you might be referring to, that survived Judge Murphy's order?
Some of it did, yeah. And again, counsel brought it up, but we did do new warrants that did not include any of the suppressed evidence when submitting them to the court, and those were signed, and there was other evidence not included in the original warrants that were obtained through the secondary warrants.
Yeah, I'll give you the last word. Go ahead.
Okay. So first of all, the state does not have to prove a relationship in 2018, 2019 to prove the charge of tampering in 2023. The relationship is not what is an issue. It's, was she duly summoned to appear in court? There's lots of language about all of that. So what their relationship was in 2018, 2019 as revealed in any of the social media posts and phone calls would not be relevant to their relationship in 2023. And nor, as I say, is the fact of a relationship the issue. The fact is, was she summoned? I have the statute, I don't have the exact language. Was she summoned for, an official proceeding? And did Mr. Demons do something to prevent that in one way? So I would submit that it is not relevant. It only serves to prejudice him. Evidence that's 4 years prior to the instance.
All right, so for this one, number 10, I'm going to defer as to this. Again, I need to see the evidence as it comes out in the trial. I presume this person is going to testify, MH, I guess. You don't have to tell me today, but I assume this person is going to testify, so that may resolve a lot of these issues, but I'll defer as to it. We're going to have to be very careful, anything that is out from Judge Murphy's prior orders, which have already been affirmed by the 4th TCA. Obviously, all of that remains out, so if there's something different, I guess I'll just have to see what it is, what the state's theory is, what the defense is arguing, what the evidence is, so I'll defer on that. Number 11, evidence and allegations from the pending murder case.
And Judge, we talked about this a little bit earlier, or you did, with regards to the facts of the murder case, and I would submit to the court the facts of the case are not relevant. The fact that MH is a witness of some sort, allegedly, may be relevant, but not the facts of the murder case. We are not here to try the murder case. We're here to try an allegation of offense that occurred 4 years later. The underlying facts of the murder case have really no bearing, right? You could be acquitted of the murder case. In fact, I referred to the case that I was reading a case about a person who was acquitted of a stalking charge, but was still tried on the tampering with a witness of the stalking case. So the guilt or innocence, the facts or lack of facts of the murder case would not be relevant to the tampering charge. It's just, did Mr. Demons do some action encourage her not to attend the trial or prevent her from doing so? So I think the fact, the court's already ruled the fact that he was charged, the fact there was some official proceedings between April and July would be admissible, but the facts of the underlying homicide case would not be relevant.
Yes, ma'am.
Judge, again, I think I said it a few times now, we don't plan on trying the homicide twice. We're not going to make a feature of the case, but some evidence as to the nature of the case, the relationship, how she was involved in the original case needs to come in.
All right, so listen, as to this one, I'm gonna deny it without prejudice to each side making whatever appropriate objection they need to at the appropriate time. I'm just gonna have to see how the evidence comes out. I will tell you, State, I'm gonna limit a lot of it. You're telling me you don't wanna make it a feature, so I'm not gonna let you make it a feature anyway. But I can't make you try the case in the vacuum, and certainly if the person that was tampered with there was some kind of prior relationship, I could certainly see a presentation of evidence where that would become relevant, or maybe not, but I'll deny it without prejudice at this point. Number 12, any evidence of alleged drug smuggling in the jail?
I think the state is in agreement with this.
You are, okay.
Again, with the impact,
All right, so based on that, that one is granted as well. So we'll get you a written order on that one right now. My clerk will do it. I wrote down next to each. Yep, what's next?
The motion for statement of particulars. And this is as to count two, obviously, which is now set for purposes of our trials in the 21st. But, Judge, as I lay out in the motion, the charge itself, first, interestingly, I could find no cases. I found a federal case that referred to the fact that there are no state cases on this crime.
There's no standard jury instructions.
Correct. And so, generally, I think with the way this is charged, it would be subject to a motion to dismiss. Because of the vagueness, and it's not just how it's charged, it's tracking the statutory language. But the cases, and the state provided them in their memo, have very helpfully, all say that a motion to dismiss is improper until there's a statement of particulars that actually outlines what are the essential facts of the crime. And here, with the charge of directing the activities of a criminal gang, it would be our position that, so the information definitely tracks the statute word for word, but there are no facts as to the essential elements. So it's unlawfully and knowingly initiate, organize, plan, finance, direct, manage, and or supervise criminal gang-related activity, to wit, which would be a good time to put in what essential facts was a criminal gang activity, but instead this information just tracks the statute and activity committed with the intent to benefit, etc. What is the activity? Or an activity in which participants are identified as gang members. Again, without any information with regards to the state's position on activity, the 3 months alleged in the information leaves it wide open as to what is the criminal gang-related activity that the state is going forward on. We are really in the dark on that, unless it's as simple as the witness tampering, in which case that is something the state can provide in a statement of particulars. But otherwise, we have a 3-month period alleged without any specific facts as to what the criminal gang-related activity that the state intends to prove would be. And it does leave us unable to properly prepare. It also leaves Mr. Demons open with regards to double jeopardy concerns. What is, for that 3-month period, what else is he potentially liable for? And while the cases cited by the state do say what we all know, which is Florida's liberal discovery rules have taken the place often of a statement of particulars, but as said specifically in the Supreme Court cases cited by the state, Dilworth, Waters, and even Lindsay, the court notes it is the liberal discovery rules coupled with the right to a statement of particulars as to the alleged essential facts the state is going forward with. At this point, it would be our position that the statutory language is so generic that it does not inform Mr. Demons what allegedly criminal acts he committed. Because it's like the statute says, paraphrasing, it's a crime to commit crimes. But we don't know what crimes are allegedly involved. So in one of the leading cases cited by the state versus Dilworth, the Supreme Court of Florida addressed the whole issue on, and it's like, I couldn't really find anything very similar, but talked about sort of information can be dismissed for vagueness if in combination with a statement of particulars, a defendant is not sufficiently informed as to the essential facts. So in Dilworth, it involved 15 counts of unemployment compensation fraud. And the counts each mirrored each other, except had different dates. And the court said a mere allegation that an accused engaged in fraudulent transactions, practices, or course of business is not specific enough to inform a defendant of what he allegedly did wrong. I would submit that the same thing is true here. A mere allegation that a defendant is involved in criminal activity is not specific enough to inform a person as to what they allegedly did wrong. So, and again, citing the Florida Supreme Court, the advent of Florida's liberal discovery rules in criminal cases, along with the availability of a statement of particulars, a defendant is no longer forced to obtain information about the charge only from the charging document. So it is our, and similar language in State Waters, I believe it is. State v. Covington. In Covington, the Florida Supreme Court, kind of think if that was, I have a copy of the court, I'd like to see it.
Again.
State v. Covington, the Florida Supreme Court affirmed a motion to dismiss, saying it was generally okay to track the statutory language, but if the information as a whole is still vague, indefinite, or exposed an accused to the danger of second prosecution, it must be supplemented by other factual allegations which set out the acts alleged to constitute the offense with precision and particularity. Here, there's nothing other than criminal activity. State v. Waters, it also talks about broad discovery and a statement of particulars is sufficient. And I sort of, and State v. Lindsay, same thing. Following the statute is generally sufficient when supplemented with a statement of particulars. One case that wasn't cited that I found interesting was
Take your time.
Yeah. And so, for one thing, I would mention that the cases cited by the state where it's a state appeal, generally it's because the trial court granted a motion to dismiss the information or indictment for vagueness. And so that's how the issue comes up, is in a motion to dismiss. And that's why the court generally says the information is sufficient if supplemented by a statement of particulars. And in fact, there are cases where they say an accused waives the argument on the vagueness of the information if a statement of particulars is not requested. So in State versus Evidentiary, I'll say, which is the first DCA case in 2020 at 297, 3rd, 991. This was a felony hazing charge at FSU. You might all remember that. And so the state did file a statement of particulars. So they still, the trial court dismissed the felony hazing charge because it just tracked the statutory language. But the appellate court found, and I was impressed with it, that the statement of particulars provided by the state, which is extremely detailed, it starts on page 4 and is recounted for several pages. So the court found with the statement of particulars, the charge itself was not too big. So it is our position that the way the statute reads, which is mirrored in the information, does not provide adequate notice and does not protect Mr. Demons against double jeopardy or being tried again for acts that are included in this time frame and under this type of regulation.
Yep, state your response.
That we filed a written response that will rely on, in addition, I would argue that the discovery provided does pretty much spell out what is used for each count. The detective does write it in his affidavits and in his public conduct.
Okay.
Could I?
Yeah, last word. Go
All
ahead.
right, thank you. One of the cases actually specifically said it was wrong for the court to even rely on the probable cause affidavit that is about the charging document. And I think from all of our prior discussions, the court knows there's this issue about the phone calls with James Howard that was an independent investigation of James Howard. That's how that came up. There's this issue about drugs in the jail. There's these other issues that are floating around. So to say discovery answers the question for it, it really doesn't. It really doesn't, because there's lots of claims of various criminal activity in the jail. And I think even Mr. Demons isn't charged with it. The co-defendant was, the use of electronic communication. But arguably, that's a crime and a criminal activity that's occurring during this time period. So I would submit that the information should be supplemented in order to withstand motion to dismiss. We have a statement of particulars as to what criminal activity the state intends to rely upon as essential facts of the case. And ultimately, the court, I think, is going to need jury instructions.
Based on that, anything else you want to say? Mike Pettigin, Petagin. Okay, so listen, on this one, I read the state's response. I'm familiar with those cases. I agree with those cases. The state tracked the statute. That's certainly enough to survive a motion to dismiss. The 4th DCA's made their position on that very clear with this judge. even when this judge didn't agree. But be that as it may, nevertheless, I do note the references, as the defense points out, to statements of particulars. So I'm going to grant it, and here's what I'm going to grant it. Every information that your office files, for example, if it's a burglary that's alleged, you track the statute for burglary, and then you say to wit, and you list the victim of the burglary, the location of the burglary, the property that was taken. For every grand theft crime that your office files an information, you track the statute, and then you put to wit, and then you put here's the property taken, and here was the value. For every robbery information that your office files, you track the statute, and then you say to wit, and you put the victim of the crime, the force that was used, the property that was taken. So based on that, I am going to grant it. I don't know, by reading the statute and by reading the information, the jury's going to be told that Mr. Demons is charged with initiating or organizing or planning or financing or directing or managing or supervising some activity. So they need to know what that activity is. So state, I'm going to grant the defense motion for statement of particulars as to count 2. I'll give you 10 days to file a statement of particulars, understanding our time constraints here, but the fact that this count's going to go last and the other counts are going to go in front of it. So it's granted with 10 days for the state to file the statement of particulars. This will cut me to get on that one. Granted, the state has 10 days to file a statement of particulars as to count 2. Ms. Howard, I think that leaves your pending motion for additional time to file a motion to suppress.
Yes, and Judge, frankly, I had hoped to have that done. I just have not had the time doing some of these other things. So I would ask if in fact, so I wasn't sure whether it actually tracks the dates that Judge Murphy already has ruled would be admissible. I have to, I think it's 4 warrants in this case, and they're like 20 to 30 page affidavits. So I have to go through and compare them to see, and so I would ask for additional time.
Are these motions that are going to require witness testimony? Because at the end of the day, if we run out of time, it's certainly not ideal, but I can hear a pending motion to suppress contemporaneously with this trial, and I might end up having to do that.
So I would suspect, but I'm not promising, that it would be a motion based on the 4 corners of the affidavit in terms of breadth, so, and sufficiency.
Which would not then require live witness
Correct.
testimony.
Correct.
Well, when I'm off the record, I guess the state's going to tell me something about my schedule this week that apparently I don't know about yet. But I can bring you back here tomorrow. I can bring you back here Friday, which is the 9th. You can appear in person or you can appear on Zoom. And if something's filed, I can do my best to try to create some hearing time for you, I'll ask the defense first. Which would you like me to do?
So, Judge, I'm sorry, Friday I have to be in Pensacola on a case. Tomorrow would be too soon.
You want to do it on Monday the 12th?
I think that, I think the 12th is the day we're supposed to exchange exhibits. So it may be, for that purpose, to be able to look at judge's exhibits.
You want to do that next Monday?
And it may not be necessary.
Okay. So let me ask this. I'll ask the defense first, then I'll ask the state. Defense, your request, I delete the all pending motions hearing for tomorrow. You don't need any time tomorrow, but I'm going to put you on. We'll just call it all pending motions as well as the trial status next Monday, which is January the 12th. Let's call it 9 o'clock in the morning. No, let me do it at 8:45, because I'm still optimistic that I'm gonna be in a trial. 8:45 on January the 12th. Defense, that's okay with you?
Yes, thank you.
State,
Judge.
that's okay with you?
Yes.
Okay. Defense, anything else I can do for you regarding Mr. Demons this morning?
No.
State, anything else I can do for you regarding Mr. Demons this morning?
No, Judge, if we may just put sidebar on the court schedule for our.
It's just not involved.
Okay.
No.
Okay, well, listen then, I'm
Try
gonna
not to get involved.
press pause, Cheese, otherwise it's gonna be in recess.